Hello everyone, this is Dhanashri Chougale and you're watching Ganga Education. Welcome back to my channel. On this channel, you will get information regarding law and competitive examination related to law. So subscribe my channel and hit on a bell icon so that you can get information regarding upcoming videos. This is part 2 of Civil Judge Junior Division Judicial Magistrate of First Class Preliminary Examination held in 2016 at Maharashtra. We have already solved question number 1 to question number 25 in previous video. Link of that video is mentioned in description box. Please go through that video also. For this video, we will solve question number 26 to question number 50. So without further delay, let's get started. Question number 26. Accused is charged under section 325 Indian Penal Code. All the facts except grievous hurt are proved. Whether he can be convicted of any offence. A. Yes, for the offence punishable under section 323 Indian Penal Code. B. Yes, for the offence punishable under section 335 Indian Penal Code. C. No, he cannot be convicted of any offence. Now option number 1, A only. Option number 2, B only. Option number 3, C only. Option number 4, A or B. And the correct answer is option number 1, A only. That is yes, for the offence punishable under section 323 Indian Penal Code. Question 27 has been removed from this examination. Now question number 28. What facts should be stated in the affidavit of examination in chief of plaintiff or defendant or their witnesses? Option number 1. All facts they asserted in their pleadings. Option number 2. Only such facts the deponent believed to be true. Option number 3. Only such facts as the deponent is able to prove on his own. Option number 4. All such facts deponent knows personally and also those he came to know from others. And the correct answer is option number 3. Only such facts as the deponent is able to prove his own. Now question number 29. In case a complaint is made by a public servant in writing in discharge of his official duties. Option number 1. It is necessary for the magistrate to examine him and the witnesses. Option number 2. It is not necessary for the magistrate to examine him or his witnesses. Option number 3. It is not necessary to examine public servant but witnesses need to be examined. Option number 4. Examination of public servant or witnesses is at the discretion of the magistrate. And the correct answer is option number 2. It is not necessary for the magistrate to examine him or the witnesses. Question number 30 has been removed from this examination. Now question number 31. Which of the following is or are the correct propositions? A. All agreements are contracts. B. An agreement which is enforceable by law is a contract. C. An agreement which is enforceable by law at the option of one party is a voidable contract. Option number 1. All the above. Option number 2. A and B only. Option number 3. B and C only. Option number 4. B only. And the correct answer is option number 3. B and C only. Now question number 32. Magistrate may order under section 125 of Criminal Procedure Code the non-applicant to pay to an applicant for maintenance at such monthly rate. Option number 1. Not exceeding rupees 5,000. Option number 2. Not exceeding rupees 1,000. Option number 3. As such a magistrate may think it fit. Option number 4. Not exceeding rupees 500. And the correct answer is option number 3. As such magistrate may think it fit. Now question number 33. Which of the following is not a document? Option number 1. caricature on a stone. Option number 2, photograph. Option number 3, currency note. Option number 4, blood stained clothes. And the correct answer is option number 4, blood stained clothes. Now question number 34. Right of the accused to keep silence is option number 1, a civil right. Option number 2, a statutory right. Option number 3, fundamental right. Option number 4, human right. And the correct answer is option number 3, fundamental right. Now question number 35. Transfer of immovable property is said to be fraudulent. Option number 1, when transfer of sale is entered to defraud the purchaser. Option number 2, when transferor is insolvent. Option number 3, when transferor has no authority to transfer. Option number 4, when transfer is made with an intention to defeat or delay the creditors. And the correct answer is option number 4, when transfer is made with an intention to defeat or delay the creditors. Now question number 36. Complaint means option number 1, allegation made to magistrate for taking action that some person committed an offence. Option number 2, allegation made to police officer that some person committed offence. Option number 3, such allegations made to superintendent of police. Option number 4, includes all the above. And the correct answer is option number 1, allegation made to magistrate for taking action that some person committed an offence. Now question number 37. First information report can be used during trial. Option number 1, only to contradict the informant. Option number 2, only to corroborate the version of the informant before court. Option number 3, to contradict and corroborate the informant when examined as a witness. Option number 4, to corroborate the oral evidence of other witnesses. And the correct answer is option number 3, to contradict and corroborate the informant when examined as a witness. Now question number 38. Suit relating to immovable property is to be filed in a court within whose jurisdiction. Option number 1, defendant resides. Option number 2, plaintiff resides. Option number 3, property is situated. Option number 4, cause of action arose. And the correct answer is option number 3, property is situated. Now question number 39. Which of the following can be transferred? Option number 1, an actionable claim. Option number 2, an easement apart from the dominant heritage. Option number 3, a mere right to sue. Option number 4, space successions. And the correct answer is option number 1, an actionable claim. Now question number 40. A person is entitled to protection of his possession of immovable property he got in part performance of a contract provided A. Contract is in writing signed by the transferor. B. Contract is for consideration. C. Transferee has performed or willing to perform his part of contract. D. Contract is registered. Now option number 1, A and B. Option number 2, A, B and C. Option number 3, A, B and D. Option number 4, A to D. All above requirements are fulfilled. And the correct answer is option number 4, A to D. All above requirements are fulfilled. Now question number 41. Period of limitation for regular suit for possession when plaintiff asserts dispossession by the defendant is option number 1, 1 year. Option number 2, 3 years. Option number 3, 12 years. Option number 4, 20 years. And the correct answer is option number 3, 12 years. Now question number 42. Lurking house trespass means option number 1, trespass openly made to commit offence. Option number 2, trespass made to insult the person in possession. Option number 3, trespass making forcible entry in the house. Option number 4, trespass taking precautions to conceal such a house trespass from the person who could object or eject a trespasser. And the correct answer is option number 4, trespass taking precautions to conceal such a house trespass from the person who could object or eject a trespasser. Now question number 43. Which of the following is or are the correct propositions? A. Partnership firm is a legal entity. B. Partnership firm is a collective name of partners. C. Hindu undivided family carrying business is not a partnership. D. Contract between the partners is a foundation of partnership. Option number 1, A only. Option number 2, A, B and C only. Option number 3, B, C and D only. Option number 4, B and D only. And the correct answer is option number 3, B, C and D only. Now question number 44. Which of the following proposition is correct? Option number 1, statement of witness recorded by police cannot be used during inquiry or trial of such offence. Option number 2, such statement of witness can be used at the inquiry or trial to contradict him when he is called as a witness by prosecution or defense. Option number 3, such statement of witness can be used at the trial to contradict or corroborate such witness. Option number 4, statement recorded by the police can be used in the inquiry or trial by the accused or prosecution to contradict such a witness when he is called by the prosecution. And the correct answer is option number 4, statement recorded by the police can be used in the inquiry or trial by the accused or prosecution to contradict such a witness when he is called by the prosecution. Now question number 45. Application for delivery of possession by the purchaser of immovable property at the sale in execution of decree is to be made within option number 1, 1 year when sale becomes absolute. Option number 2, 1 year from the date of sale. Option number 3, 3 years from the date of sale. Option number 4, 12 years from the date of sale. And the correct answer is option number 1, 1 year when sale becomes absolute. Now question number 46. Suit for specific performance of contract is to be filed, option number 1, within 3 years from the date of agreement. Option number 2, within 3 years from the date fixed for performance. If no such date is fixed, when performance is refused. Option number 3, within 3 years from the date when notice demanding performance is served. Option number 4, within 5 years from the date performance is refused. And the correct answer is option number 2, within 3 years from the date fixed for performance if no such date is fixed when performance is refused. Now question number 47. When is symbolic possession of immovable property required to be given in execution? Option number 1, person in possession is a tenant or other person is entitled to occupy property despite the decree. Option number 2, person in possession refuses to vacate and hand over possession. Option number 3, property is locked. Option number 4, property is in such a state that actual possession cannot be delivered. And the correct answer is option number 1, person in possession is a tenant or other person is entitled to occupy property despite the decree. Now question number 48. Which of the following proposition is a correct one? Option number 1, statement of a person who is dead is relevant when it relates to cause of death of anybody. Option number 2, statement of deceased made in will, deed, etc. relating to relationship by blood, marriage with the deceased and is about affairs of his family is relevant. Option number 3, statement of a witness recorded by magistrate under section 164 of Criminal Procedure Code before his death is relevant. Option number 4, statement of witness recorded under section 299 of Criminal Procedure Code but is alive can be used as evidence without his examination. And the correct answer is option number 2, statement of deceased made in will, deed, etc. relating to relationship by blood, marriage with the deceased and is about affairs of his family is relevant. Now question number 49. Which of the following propositions are correct? Option number 1, declaration granted under section 34 of Specific Relief Act A is a decision binding on the parties to the suit. B is a decision binding on the person claiming through such parties. C is also binding on other persons who are denying or are interested to deny such status, right of the party declared. D is a judgment in rem. Option number 1, A and B only. Option number 2, A, B and C. Option number 3, A, B and D. Option number 4, all the above. And the correct answer is option number 1, that is A and B only. It means is a decision binding on the parties to the suit and is a decision binding on the person claiming through such parties. Now question number 50. Application for execution of decree granting mandatory injunction is to be made. Option number 1, within 1 year. Option number 2, within 3 years. Option number 3, within 12 years. Option number 4, 90 days. And the correct answer is option number 2, within 3 years. That's it for this video. We have solved total 50 questions of Civil Judge Junior Division and Judicial Magistrate of First Class preliminary examination held in 2016. Remaining 50 questions will be discussed in next videos. So stay tuned. Thank you for listening.